All right, if you're an employer in Maine, listen up. Your HR playbook, it just got a major mandatory update. There's a new surveillance law on the books, and today we are going to walk through exactly what you need to do to get ready, and I mean starting right now.
So I have to ask, is your team ready for this? Because this is absolutely not a wait-and-see kind of situation. These new rules for employee monitoring, they're here, and they demand immediate changes to your HR workflows. So let's just dive right in.
You know, the clock is seriously ticking on this one. The law was officially enacted back on January 11th of this year, 2026. That means we are right now in that critical preparation phase. The whole thing is expected to go live this summer, probably around mid-July. So, this is your window to get everything in line.
Okay, first things first. Let's talk about Maine's new surveillance law. What exactly is this LD61, and who does it actually affect?
So the first thing you really need to get is that its reach is, well, it's universal within the state. We're talking about Public Law Chapter 524, and it applies to all public and private employers in Maine. It doesn't matter if you're a small shop or a huge corporation. If you have employees in Maine, this law applies to you, period.
Now here's where it gets really interesting. The law's definition of surveillance is incredibly broad. I mean, we are not just talking about cameras here. This covers pretty much any monitoring of what an employee does on their computer or phone through tracking software. So yeah, think things like keystroke logging, checking out internet history, or even using those remote desktop tools.
But, the law does make a really important distinction. It draws a clear line between general security stuff and directly monitoring what an employee is doing. So for example, those security cameras you have in the lobby for safety or a GPS tracker on a company-owned truck, that's not considered surveillance under this law. But monitoring someone's internet activity or tracking their keystrokes on their work computer, oh yeah, that is definitely covered.
Okay, so this is the really crucial part for HR teams. Let's get into the key changes and what you and your team actually need to start doing differently, like right now.
First up, transparency. It's not optional anymore. It is absolutely mandatory. This means you need to add a brand new step to your hiring process. You now have to tell job applicants right there in the interview process if you monitor employees. For your current team, you've got to draft a written notice and send it out at least once a year. And, super important, if you decide to roll out some new monitoring software, you have to let your employees know before you even think about turning it on.
The law also draws some really clear lines in the sand, things you just can't do anymore. For starters, no audiovisual monitoring in an employee's home or their personal car, unless it's absolutely essential for their job. And here's the big one. Especially with remote work, you cannot force an employee to install data tracking apps on their own personal devices. That's a huge change.
All right, so what do you actually need to do to get ready for this? Let's walk through a practical, step-by-step action plan to make sure you're totally compliant before that summer deadline hits.
Okay, here's a simple 4-step plan to get you started. Step 1, audit your tech. Get together with your IT folks and make a list of every single system you use that monitors employees. Step 2, update your handbook. You're going to need to revise your privacy and acceptable use policies to align up with this new law. Step 3, prepare your notices. Start drafting that new disclosure for interviews and the annual written notice for your current staff right now. And finally, Step 4, train your team. It is so important that your HR staff and all of your supervisors understand these new rules inside and out.
Okay, let's zoom in on something that affects pretty much everyone these days, remote work and bring your own device or BYOD policies. The new law has some really critical details here.
And this is a big one. The rules are completely different depending on who owns the device. It's pretty simple for company-issued gear, like laptops or phones. You can monitor them, as long as you give employees all those required notices we just talked about. But when it comes to personal devices that an employee is using for work, well, the power dynamic totally shifts.
And this quote, it's straight from the law itself, and it could not be clearer. It basically says an employee has the right to say no thank you if you ask them to install a surveillance app on their personal phone or computer. This is a really significant new right for employees, and it's something you have to respect in your BYOD program.
But let's be clear, this right does have its limits. There's a huge difference between surveillance software and essential security software. So while an employee can say no to a keystroke logger, they probably can't refuse to install, say, the security software they need to safely connect to the company network. That's often a condition for being in the BYOD program in the first place.
All right, so let's talk about the stakes. Why does all this matter so much?
Let's look at the deadlines and, just as important, the penalties if you don't comply. So just to recap the timeline, because it's so important, the law was enacted back in January. Right now, we are in the preparation phase. This is your time to get all your ducks in a row. Come mid-July 2026, that's the estimated effective date, and that's when enforcement can officially kick in.
And what about those penalties? Well, they're pretty straightforward. We're talking up to $500 per violation. And think about that for a second. If you, for example, forget to send out that annual notice to your entire staff, wow, that could add up incredibly fast.
And just so we're all clear, this isn't just some friendly suggestion. The Maine Department of Labor is the agency that will be enforcing this. So compliance isn't just a good idea, it's an absolute must.
You know, as you're going through all these steps to get ready, it's worth taking a step back, because this is about more than just checking boxes for compliance, right? It's really about transparency. So the bigger question to leave you with is this: how is this new level of openness actually going to shape your workplace culture?